inside Number 10 set out precisely why, in his experience, Sir Keir Starmer would have known about this perhaps within hours.
You know, in the House of Commons, you have legal privilege. Why did the Speaker of the House, Sir Lindsay Hoyle, Labour, why did he tell MPs that they mustn't discuss this?
And I took that to be very, very credible information. And it was extraordinary at Prime Minister's questions today to see the Speaker, Lindsay Hoyle, effectively shutting MPs down.
Keir Starmer's decision on the Southport killer case has ignited a firestorm of controversy. As public outrage boils over, MPs are demanding nothing short of the death penalty for the heinous crimes committed.
We have to be very, very careful about the suspect, the defendant, who has been charged now with the murders of 3 kids and attacking kids. The Prime Minister, the Home Secretary, and indeed the police knew that there was a terror-related aspect to Axel Rudakabana.
Well, I think the timing was very carefully engineered. I think my own sense is that Keir Starmer and the Home Secretary knew perfectly well about these extra details.
But amidst the clamor for retribution, Starmer stands firm. He won't change the law that allowed the killer to avoid a life sentence. What's behind this seemingly baffling decision? The answer lies in a complex web of international agreements and child rights laws that few saw coming. The Southport killer case has sent shockwaves through the nation, leaving many Brits grappling with a sense of injustice. How could a 17-year-old who committed such heinous crimes walk away with a mere 52-year sentence? It's a question that's been reverberating across the country, from Parliament to local pubs. The details of the case are nothing short of horrifying. 3 young girls, Alice Da Silva Aguiar, Bebe King, and Elsie Dot Stancombe, brutally murdered. Their ages, 9, 6, and 7. It's enough to make anyone's blood boil, and boil it has. Public outrage has been swift and fierce. Many feel that 52 years is a slap on the wrist for crimes of this magnitude. It's as if the justice system has failed not just the victims and their families, but society as a whole. The sentiment is clear. This punishment doesn't fit the crime.
The government's own independent reviewer of terrorism legislation, Jonathan Hall Casey, has said repeatedly recently that it is important in incidents of terrorism that the authorities put out more information sooner.
All of us in this House have a choice to make, including both candidates to be the next Tory leader. They can either support the police in their difficult task. I think it's very important, first and foremost, that in all cases, including the particularly difficult case that the Speaker mentioned earlier, that the police and prosecutors are able to do their difficult job.
But it's not just the public who are up in arms. Politicians have joined the chorus of dissent, with some even calling for a return to the death penalty. Southport MP Patrick Hurley didn't mince words when he described the sentence as not severe enough. He's urged the Attorney General to review it, echoing the broader public sentiment that something's got to give. Critics, including politicians and victims' families, are demanding a review of the law. They want to see whole life sentences for underage offenders in exceptional cases. The argument: the current legal framework is woefully inadequate when it comes to reflecting the severity of certain crimes. But here's where things get sticky. Enter Keir Starmer, caught between a rock and a hard place. On one side, he's facing mounting pressure to change the law. On the other, he's bound by international agreements that tie his hands. So why won't Starmer budge? The answer lies in the UN Convention on the Rights of the Child. It's a pesky little thing that's causing quite the headache for the Labour leader. The Prime Minister's spokesperson made it clear. The government's hands are tied when it comes to extending whole life orders to under 18s. It's not just a matter of domestic policy, it's about upholding international law. But is that enough to satisfy a grieving nation? The Southport case has ignited a fierce debate about the adequacy of current UK laws regarding sentencing for underage offenders. There are calls for amendments to allow for more severe penalties in cases of extreme violence. It's a debate that's likely to rage on, with no easy answers in sight. As the UK grapples with the aftermath of the Southport tragedy, a chilling reality is emerging that threatens to upend our understanding of terrorism. Keir Starmer's recent comments have exposed a glaring weakness in our legal system, one that could leave us dangerously unprepared for a new breed of extremist. Gone are the days when terrorism was solely the domain of organized groups with clear political agendas. While these threats still loom large, Starmer warns of a far more insidious danger lurking in the shadows: lone wolf attackers who operate without a distinct ideology. These individuals, often driven by a toxic cocktail of personal grievances and extremist influences, are slipping through the cracks of our current counterterrorism efforts. The Southport killer case serves as a stark reminder of this evolving threat. Axel Rudakubana, the perpetrator of those heinous crimes, had been flagged to the UK's counterterrorism program, PREVENT, on multiple occasions, yet somehow he managed to evade intervention. As Starmer puts it, this failure leaps off the page, exposing the critical shortcomings in our ability to identify and neutralize these lone wolf threats. But why are our current systems failing so spectacularly? The answer lies in the outdated definition of terrorism itself. In the UK, terrorism is still primarily understood as actions intended to influence government or intimidate the public for political, religious, racial, or ideological causes. This narrow scope leaves a dangerous blind spot when it comes to individuals like Rudakubana, whose motivations may not fit neatly into these categories. The implications of this legal loophole are staggering. How can we hope to prevent future atrocities when our very definition of terrorism is stuck in the past? It's a question that's keeping lawmakers up at night and sending shockwaves through the corridors of power. Starmer, recognizing the gravity of the situation, has committed to a comprehensive review of counter-extremism systems. But this is no small task. It's not just about tweaking a few regulations. It's about fundamentally reshaping our approach to national security. The Labour leader's comments suggest that legislative changes may be necessary to address these new threats effectively. Meanwhile, the Home Office isn't sitting idle. Home Secretary Yvette Cooper has announced a thorough review of the PREVENT program in the wake of the Southport attack. Their goal? To ensure that serious cases like Rudakubana's don't slip through the net in the future. But critics argue that this may be too little, too late. After all, how many more tragedies must we endure before our legal system catches up with the realities of modern terrorism? The challenge facing Starmer and his colleagues is monumental. They must find a way to broaden the scope of anti-terror laws without infringing on civil liberties or stigmatizing vulnerable individuals. It's a delicate balancing act, one that requires nuance, foresight, and political courage. As the Southport case continues to send shockwaves through the UK, Keir Starmer finds himself caught in a political maelstrom. The Labour leader's refusal to change the law has sparked a fierce debate about justice and international obligations. Experts are now calling for a significant overhaul of the UK's anti-terror policies, suggesting that the current framework may be ill-equipped to handle the threat posed by lone actors like Axel Rudakubana. But Starmer's hands aren't entirely free. The UK's commitment to international conventions, such as the UN Rights of the Child, presents a formidable obstacle. Breaching these agreements could have far-reaching consequences for the nation's legal standing and its reputation as a champion of human rights. As the public demands action and politicians clamor for change, Starmer must navigate this treacherous landscape with utmost care. The Southport tragedy may well prove to be a watershed moment in how the UK addresses evolving terrorist threats. But as the debate rages on, the real challenge lies in crafting policies that can prevent future attacks while upholding the principles of justice and international law. It's a delicate balancing act, and all eyes are on Starmer to see if he can pull it off.